Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We are continuing with our special series discussing providing our personal opinions on the matter styled as State of Idaho versus Brian C. Kohberger. Today, I would like to direct your attention to a filing of February 24th, 2023, which I find very interesting. It is a stipulation, which is an agreement between both sides, signed by counsel for the state of Idaho and counsel for Mr. Kohberger, where they are coming forward and asking the court on that day to release a memorandum that had not been available to the public before. It is a summary of a conference that had occurred the month before, specifically on January 13th, 2023, that had not been published on the docket until that date. Attached to this stipulation is the memorandum, and what it states is that a conference was held, and it identifies the parties that participated and who was in the room during that conference, in the room being the virtual room, because this was a virtual conference conducted via Zoom. It was called by the court, Judge Marshall. She was obviously present. Her judicial assistant, this memorandum states, was also present. And then you would expect that if this is a conference for a matter involving Idaho versus Kohberger, that attorneys for Idaho and for Kohberger would be there, which they were. But what's interesting to me is who else attended. We know that Mr. Gray attended on behalf of the Goncalves family because his name is published in the memorandum, but we don't know the names of the other 2 to 3 attorneys who attended because it's heavily redacted. It's at least 2 and possibly 3 other attorneys, besides counsel for the state, for Mr. Kohberger, and for the Goncalves family. Those other attorneys' names are heavily redacted, as are the names of their clients who are described as potential witnesses in this case. And the purpose of this conference was to address the non-dissemination order that had been entered on January 3rd, 2023. The court gave her expectations that the parties in the room would comply with that non-dissemination order, aka gag order. She cited to legal authority. She cited to their ethical obligations to comport with that order, and she talked about how important it was that that order be complied with to ensure and help to ensure Mr. Kohberger's right to a fair trial. And there were even some hints about a possible bar complaint if there was non-compliance. Then there was documented in this memo, and it's quite extensive information. It's 2.5 pages long, but it's single space. So there's a lot of information provided here. Mr. Gray speaks a lot, or he's at least, his thoughts are summarized a lot in this memo. He, for example, states that he doesn't see where there could be found a juror who was not heard about this case. One of the other attorneys, whose name's redacted, expressed his concern that every time he speaks, that there's a record that's made. And then there is one of the attorneys whose name is redacted, who states that he has instructed his client to not give any media interviews, and he stated that he would not give media interviews also. And then there's some talk in this memorandum that one of the witnesses has received harassment. It's not described what that means, or obviously who it was, because that name is redacted. If you have an interest in this case, I would definitely recommend that you review the record on that date and read the memorandum. Thank you for joining us today.